Inherited property, it's a massive opportunity in Nigerian real estate, right? But man, it can also be a total minefield. One wrong move and your investment could literally vanish. So in this explainer, we're going to walk through how to do this the right way to make sure your investment is rock solid. Let's get into it. So picture this. You find the perfect piece of land, you meet with the family, you shake hands, you think the deal is done. But what if I told you that entire agreement you just made could be completely, legally worthless? It's a shocking and frankly harsh reality for a lot of investors. Let's dig into exactly why this happens.
All right, first up, let's talk about what I call the inheritance trap. It is such a common mistake, and it's one that can torpedo your purchase before you've even really started.
And here's the heart of the trap. Look, it doesn't matter who you make the deal with. It could be the eldest son, the entire family could be in the room nodding in agreement. None of it matters. Under Nigerian law, if they don't have a very specific document from the court, they have absolutely no legal authority to sell. That means any paper you sign is basically void on arrival.
Think about it this way. It just takes one missing legal link to break the entire chain of ownership. This isn't about having most of the paperwork right. You either have the single correct legal instrument, or, as far as the law is concerned, you've got nothing.
So how do you steer clear of this massive trap? Well, in this next section, we're going to look at the 2 legal keys, if you will, that you absolutely must have to unlock the estate and make your purchase legitimate.
It really all boils down to one simple question. Did the person who passed away leave a valid will? If the answer is yes, then the key you're looking for is called a grant of probate. If the answer is no, then what you need is a letter of administration. Let's break down what each of these really is.
A grant of probate is basically the court's official stamp of approval. It says, yep, this will is the real deal, and it legally empowers the people named in that will, they're called the executors, to actually manage and, you guessed it, sell the property. Without this grant, the will is just a piece of paper with some wishes on it.
Now, on the flip side, if there is no will, and the legal term for this is dying intestate, the court has to step in. It issues a letter of administration, which appoints specific people, usually the closest relatives, to be the administrators. This letter is the only thing that gives them the legal power to do anything with that estate.
Okay, moving on to Section 3, your legal shield. We know what these documents are now, but let's talk about why they are completely and utterly non-negotiable for any serious investor.
It really comes down to 3 things. First, authority. It clearly establishes who has the right to sell. No guesswork. Second, legitimacy. It confirms your deal is legally sound. But most importantly, it's about risk mitigation. This document is your shield. It's what stops some long-lost cousin or a forgotten creditor from popping up 5 years down the line trying to claim your property.
And hey, don't just take my word for it. Here are the stakes, in black and white. This isn't just good advice, it's a hard legal fact. The courts have said over and over again that any deal made before one of these documents is issued is legally defective. And you know what that means? It means a judge can just, poof, set aside your entire purchase. Okay, so you get it. These documents are crucial. Section 4 is your playbook, your practical, step-by-step guide to doing your homework, your due diligence as an investor.
Let's walk through your 5-step checklist. Step 1. And this is simple. Just ask. Are you the original owner, or are you an heir? If they're an heir, boom. Step 2. You demand to see either the grant of probate or the letter of administration. Step 3 is so important. Don't just take their word for it. Go to the court that issued it and verify it yourself. Step 4. Read the document. If it names 3 administrators, then all 3 of them have to sign off on the deal. Not 2, all 3. And finally, step 5, you close the loop and secure your title with the proper registration.
And please, please, listen to this piece of advice. It could save you a fortune. Getting these grants can take months, sometimes even years. Do not give them any money up front. No deposit, no commitment fee, nothing, until you have physically seen and personally verified that grant is real. You've got to protect your capital.
All right, our final section. And honestly, this might be the single most important thing we talk about today. You've seen the grant, you've verified it at the court, so you're good to go, right? Wrong. There is one more critical distinction that separates a secure investor from someone who's walking into a future headache.
Here it is. This is the takeaway I want you to burn into your brain. The grant is an enabling document. It is not a title document. Understanding this one simple difference is what separates the pros from the people who end up losing their money.
So what on earth does that mean for you in practice? It means the grant simply gives the sellers the green light to sell. That's it. It does not transfer ownership to you. Not at all. You still have to do the whole 9 yards, get a deed of assignment drawn up, secure governor's consent if you need it, and of course, register your title at the land registry. Think of it like this. The grant is the key that starts the car, but you still have to do the paperwork to actually get the title in your name.
So here's the thought I want to leave you with. The next time you're in a deal and the seller proudly hands you a grant of probate, you'll know exactly what to think. You'll think, great, that's step 1. Because now you understand that document isn't the finish line. It's just the starting block. Thanks for joining this explainer.